This class was about arbitration, which is a process that litigants can choose instead of litigation. So, where a settlement can end a litigation or prevent one from going forward if you settle before anybody files a complaint. Arbitration is basically an agreement between the parties to a conflict of some sort, to have somebody other than a judge adjudicate their conflict. So, an arbitrator. The Federal Arbitration Act of 1925 governs arbitration in the US in federal courts. And under that act, it basically says parties can pre-agree to arbitrate a conflict that comes up later. So you can have a contract now that says whatever conflict we have in the future, we will not take to litigation in an Article 3 court. We will arbitrate instead. And then if one of the counterparties doesn't do that, if they bring litigation in court, the other one can ask the court to dismiss that lawsuit and have it arbitrated instead in front of an arbitrator. And the FAA, the Federal Arbitration Act, basically requires courts to do this. There's a lot of interesting history of the Federal Arbitration Act that kind of indicates that when Congress passed it in 1925, it was really not thinking about the regime that we currently live under. And I've put up a really nice article on Husky CT in case you're interested in this, that walks you through the enactment history and kind of shows what people thought that they were voting for at the time. But the current state of the Federal Arbitration Act reads the exceptions that are written into that act quite narrowly. So there's a couple of exceptions. One is that the FAA doesn't apply to employment contracts for seamen, railroad workers, or any other class of workers in interstate commerce. This has been interpreted quite narrowly because at this point, of course, many of us would be considered to be engaged in interstate commerce, but the Supreme Court has not allowed the broadening of our understanding of what interstate commerce involves to affect its interpretation of the FAA. And so employment contracts in general are, under current case law, subject to arbitration agreements, except for seamen and railroad workers, in other words, transportation workers. The other part that has been interpreted narrowly, which we focused on in our discussion, is that the court can set aside an arbitration agreement on such grounds as exist for the revocation of any contract. Concepcion interpreted that exception, that the court can set aside an arbitration agreement on such grounds as exist for the revocation of any contracts, to mean that a law, a state law, for instance, or a local rule can't treat arbitration differently than any other kind of contract provision. So once you have a special rule about an arbitration agreement, you're already violating the FAA under this reading. And the only way that you can invalidate an arbitration agreement is through the kinds of applications that you have for every contract. So duress, fraud, unconscionability. And you'll note that the notion of unconscionability has actually gotten narrower over time. So there are fewer things that count as unconscionable, and therefore fewer ways to invalidate an arbitration agreement. Furthermore, under Concepcion, the court ruled that an arbitration agreement can preclude arbitration and litigation as a class. So it can basically prevent people from pursuing class-wide interests in any forum. Finally, we discussed in class how this jurisprudence seems to be fairly well entrenched at the Supreme Court, and therefore obviously controls all courts below. And so the real avenues of changing it are through legislation in Congress and regulation in the federal administrative agencies.